Thank you, Madam Chair. Mr. Buchanan, thank you for the opportunity to appear today to give NASBIC's recommendations for improving the SBA's access to capital programs. I have provided some background on the SBIC program in my written testimony, but will jump immediately to our recommendations. First, improve the debenture SBIC program, which runs at a zero subsidy. The House Small Business Committee, the full committee, has already led the way by securing passage by the full House of H.R. 3567, the Small Business Investment Expansion Act of 2007. The bill contains two provisions, Sections 101 and 105, that are very important to both greater growth in the program and greater potential for each individual SBIC to help every small business in which it invests. Both provisions would make the program more attractive to private investors and to private management teams, thus leading to greater growth in the program. Neither provision has been opposed by the administration. Unfortunately, the counterpart Senate bill, S-1662, is bogged down because of a hold placed on the bill by a single senator opposed to the SBIC program as a whole. We hope this can be remedied prior to adjournment of this Congress. Second recommendation, revive the participating security program. Warren Buffett said this week, by any common sense definition, we are in a recession. That fact will make the availability of equity capital even more important to America's small businesses. Equity capital is the foundation upon which every company is built. As outlined in my testimony, the participating security program has been a great success in providing that equity capital, having provided $14 billion in equity investments since 1994. Yes, the government will lose money on the program, a result of losses from the 2000 recession when all investors lost money, and SBICs no more than most. But the losses will be substantially less than projected by OMB. OMB says that the recoveries from participating security SBICs in liquidation will only be 35%. In fact, recoveries for FY06 and FY07 ran at 64%, 83% more than forecast by OMB. Over $600 million was recovered in just 2 years. What is debt? The Credit Reform Act of 1990 does not define the word debt. Absent a definition within the statute, words are subject to the Supreme Court promulgated plain meaning rule of statutory construction. Words must be given their ordinary meaning. The word debt is defined in many ordinary contexts: a duty or obligation to pay money, a note or bond which represents an amount owed, a liability on a claim. Based on these definitions, both generally accepted accounting principles, GAAP, and SBA's own SBIC regulations require that participating securities be listed as debts on the financial statements of all participating security SBICs. How can the government have it both ways? Section 303 of the Small Business Investment Act makes it clear that a participating security is a debt for subsidy scoring. Section 303G1 states participating securities shall be repaid not later than 15 years after their date of issuance. The section creates an unambiguous obligation to pay money on the claim created by the security. Section 303G5 states the only debt other than leverage a company issuing participating securities may have outstanding shall be temporary debt. The phrase only debt other than leverage is unambiguous. Congress considered both participating securities and debentures to be debts. Finally, 303J states all fees, interest, and profits received by the administration under this section shall be included in the calculations made by the Director of OMB to offset the cost, as defined by the Federal Credit Reform Act of 1990, to the administration of purchasing guaranteed debentures and participating securities. Section 303J makes crystal clear congressional intent that the securities issued under the program qualify for subsidy scoring. Only if qualified could receipts be used to offset costs. Since the Federal Credit Reform Act was passed 8 years prior to the legislation creating the participating security program, it must be assumed, it has to be assumed, that Congress knew the law. If it did not intend participating securities to be debts for the purposes of the Federal Reform Act, it would not have made the receipts deductible from costs under 303J. With OMB so wrong and so intransigent, a simple legislative change would revive the participating security program. I've provided the language for that change in my testimony. It's very simple. It just says in the Enabling Act, participating securities guaranteed under this subsection shall be considered debt securities for all purposes related to the Federal Credit Reform Act. Amending the SBA, the Small Business Investment Act as suggested would correct the unjustifiable holding by OMB and CBO and again make the participating security program a very effective partner in providing scarce equity capital to America's small businesses. Thank you for your consideration.